Welcome to the Law Matters, and of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you need to contact a lawyer. Perhaps will help you to determine that you may actually handle some issues yourself. If you do decide to connect with outside counsel, professional counsel, you'll be better prepared, and as a result, so will the professionals you select. Our goal, of course, is to help you achieve better results while you save time and money. The Bazar and Associates law firm in East Providence continues to help us with the various issues that we tackle, and we want to thank them and once again welcome Attorney David Bazar. So today, David, you're going to have a second challenge. You're going to be serving not only as the attorney, but also in this new topic, the mediator. So our topic for the day is alternative dispute resolution. Just about everyone agrees that litigation is something that you'd like to avoid. It's expensive, it's time-consuming, it's emotionally draining, it's unpredictable, and for some, there might actually be alternatives. We're going to explore those today. Might alternative dispute resolution work for you, mediation or arbitration? We'll go through them and see if it might work for you. It's become increasingly popular to see that mediators are used for what you might recognize as perhaps either divorce or some child custody kinds of cases. Actually, they're used for businesses, for landlord and tenants, and the list goes on. And interestingly, in preparing for this, we found that Puerto Rico creditors are actually open up to using alternative dispute resolution, specifically mediation, in bankruptcy court. Our Pope is urging it in the North Korean crisis, and even Florida, in some cases now, is demanding that it's used first before people go to courts, because obviously the dockets are quite full. So, David, explain what is alternative dispute resolution. There's arbitration, and what's the difference? What are they?
So, in the court sense, as you're using alternative dispute resolution, it's an alternative to having the case litigated in front of a judge or a jury. And it can come in the form of mediation, which is when the parties meet before a mediator and the case is settled really by the parties with the assistance of a mediator, or through arbitration, which is a mini trial where the arbitrator decides the result of the case, and that can either be binding or non-binding arbitration, and there are a lot of different ways that that comes into play. So in the court sense, that's ADR, or alternative dispute resolution. But as you mentioned, mediation can be used in a number of other different areas as well. And in fact, I do serve as a mediator, and I've mediated a number of cases that don't involve the court in any sense. So
let's make one distinction, though. If you're an attorney, if you're a lawyer, you could be a mediator, but not all mediators are lawyers.
That's correct.
And how do you get certified? How does that happen? Do
Well,
you take classes? How does that work?
For me, I did take mediation classes. So of course, I did many mediations before I became a mediator as a lawyer, and I understood the process, and I learned from some of the best that do the mediations. But I thought it was very important for me to become a mediator, to go through the process of taking the courses that are available, and there's a number of different courses that are available, so that I would be a trained or certified mediator. And for example, at one point in time, the family court had a list of mediators, and in order to become appointed to that list, you needed to go through the training so that they knew that you were certified and trained as a mediator. The court actually now has hired mediators who work for the court and will mediate certain cases at the family court.
At the family court. So help us understand, if you are a lawyer and you are a mediator, when you're a mediator, you can't be the lawyer. The distinctions are clear. There's sometimes the perception that there could be a conflict of interest. How do you handle it so that there is not one?
Okay, so there's a couple of things that you raise. The first thing is that mediators are not necessarily lawyers. There's no requirement that you have a law degree or a psychology degree or a sociology degree or any kind of degree whatsoever. It's really the training and the experience of being a mediator. Now, as a lawyer who serves as a mediator, we explain at the beginning of each new case, new mediation, that even though I'm a lawyer, I don't represent either party to the case. I really will not be giving any legal advice, but merely serving as the person who is trying to bring the two parties together. And for me, the most important thing about mediation is really the conversation and discussion that the parties are having, because it's the parties who resolve the case. And what you're trying to do is get them to listen to each other, understand each other's position, and therefore have a little bit more of a sense, a little empathy as to what it's going to take to get the case resolved.
Is it your responsibility to tell them up front, whoever it is that's before you to have a case mediated, that you cannot, in fact, give them either one, legal information, that you can only facilitate the process? Is that true?
Well, here's how I think it works. And of course, it really depends on the type of case being mediated. So what I was talking about when I was first giving the explanation as a mediator would be a family court mediation. And so what I would explain to the parties is that both of them have the right to consult with lawyers as the mediation process is going on. Mm-hmm. But beyond that, they probably might need to consult with accountants. They might need to consult with real estate experts, business evaluation experts, because I don't give any information or expertise in any of those areas as the mediator. So I don't give legal advice, I don't give accounting advice, I don't value real estate. I am just a mediator. The fact that I'm a lawyer is sort of secondary to the fact that I'm a mediator in that case. So in the mediation, I only serve as a mediator, and I encourage that the parties, depending on the type of case, seek out information from whatever expert may be necessary, whether it be a lawyer or an accountant or a real estate expert.
So if one comes into you, do you suggest either way, perhaps you could consider mediating this versus litigating this, whether it was family court or business partners?
So using the family court for an example, I will often explain at the beginning of mediation the process of how mediation works, which is that we will meet together, we will disclose to each other, the parties that is, all of the information that they need to have an informed mediation and to have an informed result. That at times I will meet with one party alone or the other party alone just to discuss some things and get some information that they may or may not want shared with the other party, and to encourage some things that I heard or that they may not have heard to make sure they heard it, and then meet again together. I call that caucusing when we're separate, and then meeting together to try to bring all of the issues to a resolution. So there may be an issue that comes up as we're going along as to one party thinks the house is worth $500,000, the other party thinks it's worth $300,000, but neither of them have gotten any information on that. So at that point in time, we would put that issue aside and I'd say, go get information on that and bring it back. And first thing we need to do is to agree on what the value is before we can agree on how to divide up the asset. So there's a lot of that back and forth that we do, and that's the process that's described. And part of the description at the beginning is that the cost of mediation is oftentimes much less to go through the mediation, hire an attorney to put the divorce through, if we're talking about family court, than it is to hire two attorneys, fight the case out in court, have trials and appeals and whatever else you might have, and get a result that may not be as good as the two parties who are resolving the case, because they know the case much better than whatever judge the case may end up in front of, and they lose control over the resolution when they put it in the hands of a judge.
Interestingly, when I was reading a little bit about this, there's always a range, all fees, but for a mediator, $200 to $500 an hour. When you end up with a divorce case, could be $20,000, $50,000, and more zeros depending on the assets of whoever's involved.
That's right. And there's a number of different ways mediators may charge for their services. It could be hourly. And when you say $200, $300, $400 an hour, remember that's divided by two.
Yes.
Whereas if you say the same for a lawyer, that's each.
Each.
So
good point,
it's
David.
a big difference.
So if someone is having a dispute, understandably, apart from the facts, there are emotions. What do you say when you understand, of course, that whenever there's a dispute, there's some emotional factor? How do you handle, or what would you say to someone who says, I want to kill that person, I can't possibly mediate it? You as a mediator, when you're a mediator, can you still listen to someone vent, calm them down? Is that part of what you do or a mediator does?
Sometimes it's actually helpful for the parties to get that out up front, and then we say, okay, have you had enough? Can we move on? Depends on what it is they're getting out. Sometimes it's actually very important information for the other party to hear. And sometimes you just want to say to them when we're talking about, for instance, a child custody dispute or issues around the children. I don't say this, but sometimes you feel like saying, it's more important that you love your children more than you hate your spouse. So put those feelings for the spouse aside and think about the child. So the way as a mediator, I as a mediator would do it would be to try to emphasize the common issues that they have and the common ground that they have so that they start looking at it. And it reminds me of a case I had where they were down to just a few issues about days of parenting time when the husband would take the children, the wife would have the children. And there was one particular day that the wife wanted, that the husband didn't want to do, he wanted to do a different day. They never really talked about it. When they did, finally it came out that he had something to do on the day that the wife wanted and have the children. She didn't. She didn't realize that that was the day he did this particular task. She was encouraging him to do that task, so she switched the day. It's a matter of communication, and that's really the most important thing that can come out of, besides the resolution of the case, the ability to communicate with each other.
And as a mediator, you facilitate this, but then there's the evaluative process. You have to figure out what really is right. So do you often have to weigh in on what is truly right, if we don't want to say the word legal because it's in a mediating situation? How do you deal with that?
Yeah, so there's certain times where the party needs to, here's what I was trained as a mediator. One of the things they said is either party can give up the farm, he said, the teacher, so long as both sides know what the farm is. So in other words, you can give up all your rights, but you need to know your rights. So if someone is giving up a lot of rights that they have, I wouldn't weigh in on telling them they shouldn't do that, but I would encourage them to make sure that they consulted with an attorney so that they understood what it is that they're giving up.
Sounds right. And when it comes to mediation and there's a divorce, you understand that that's a permanent separation. But in the business environment, I understand that mediation could or should or might be done, or something might be done in advance before there's actually a dispute. When you're in love and getting married, everything's going to be fine. When you're just formulating a partnership, you're sort of in love and everything's going to be fine. It doesn't always work that way. So how do you prophylactically work with people who are starting a business so that that can be a mediated situation if something erupts versus the dissolution of it?
As I said at the beginning, I've mediated a lot of cases that are outside of the court system. I've mediated cases with business partners on issues that they needed to resolve. Obviously, that mediation came after the issues already arose. I've mediated family issues, family disputes that are not court cases necessarily, that could become disputes in probate court, fighting over an estate, that could become court cases, but we've tried to resolve them before they became issues in probate court. I've mediated cases with organizations where there were disputes between various constituents in the organization, school and students, and some issues between those parties. So the mediation is different in those cases because sometimes what we need to start with is to really lay out what the issues are and what is the dispute, because one party may have a different view of what the dispute is than the other party does. So it's important to say, all right, let's crystallize the issues, let's know what the issues are, and then let's try to resolve them. Because if they think they have different issues, there's not even a common starting point for the mediation at the beginning. So understand what the issues are, and so prophylactically doing that, you might want to meet with the shareholders or the business partners or whoever it is and say, these are some potential issues that you may need to think about before they come up, and have at least in place between the parties a way of resolving those issues as they come up.
And they can be mediated. And at the same time, if we speak a little bit about arbitration, labor and management and those issues, arbitration, there's binding, non-binding? Explain the difference and who cares about it? Why does
So,
it matter?
Labor contracts, union contracts, spell out what the process is going to be to resolve those things. So those are often binding arbitrations, and the binding arbitration means that the parties will get together with the arbitrator and they'll go back and forth. We've seen these things sometimes go on for days and weeks, but what the process is to come to an agreement, and at the end of the day, it's binding on the parties. So it's sometimes in the form of a mediation, but oftentimes there's a number of different kinds of arbitrations. Baseball, for example, and we call this baseball arbitration, when the players have a dispute with the team as to what their salary is going to be, they're arbitration eligible but not eligible for free agency, they go to an arbitrator. And the arbitrator hears the team's case and the player's case. Each side in that case submits what the proposed salary would be, and the arbitrator has to choose one or the other. So there's sort of an art to trying to pick what number you're going to give so that the arbitrator is more likely to pick your number. We very rarely use that type of arbitration outside of baseball, but it can be. But it's the same idea, is that the arbitration, if it's a binding arbitration, at the end of the day, whatever the arbitrator decides is going to be the final decision and binding on all parties.
When there's arbitration, is there someone representing each side and then an arbitrator who is picked by each of the two sides to be the final decider?
Sure. And again, depending on the type of arbitration that's involved, the contract may, if it's a union contract, for example, spell out how the arbitrator is selected. In a court setting, Superior Court, for example, there is a requirement that almost all cases in Superior Court, civil cases, go through court-annexed arbitration, where there's a list of arbitrators who are qualified to be arbitrators for these Superior Court cases. I'm actually on that list as well. And so the parties can either agree or stipulate to who the arbitrator will be, the lawyers pick that, or if they can't agree, the court will send to them a list of 5 arbitrators, and they each get to strike 2. So after they're stricken, whoever's left is chosen to be the arbitrator in that procedure.
And so binding means that person decides, it's the end of discussion. There's no next step to turn it to litigation?
Well, the court-annexed arbitration is not binding. So after the arbitrator makes his decision, there's a 20-day, I believe, appeal period for either side to pay a fee of $200 or something of that nature, so that the case is then sent back to the Superior Court and put back on the trial calendar list.
Is there ever an occasion where, upon the first or maybe second meeting for mediation or non-binding arbitration, that someone would likely say, this really needs to be litigated, that's the only option? Are there some occasions where it's clear?
Yeah, and that happens. I would say there are some cases where the parties on mediation, for example, just are never going to agree on anything, and the only resolution is through litigation.
Is it true that mediation, apart from the fact that it should save time and grief and anguish and money and all the rest, that the court systems, as we know, that they have very heavy dockets, that they have the ability to unilaterally say everything has to go to mediation before it ever even gets to the docket? In Florida, apparently, that's happening. Is that likely to become the new standard op?
Well, it is the standard op in Rhode Island and Superior Court. Those cases that are filed civilly that fall within certain parameters are required to go to arbitration, court-annexed arbitration, before they can go to trial. In federal court, there's a number of different ADR types of resolution, mediation, arbitration, whatever. The judges require almost all cases, civil cases, to go through some form of ADR in federal court in Rhode Island. And in family court, miscellaneous cases. Those are cases where it's not husband and wife, but parents of a child or something of that nature. The M cases, as we call them, are required to go to mediation in family court before they're heard by a judge.
Is it ever a matter of the size of the assets that will determine whether or not something has to go to court? Is that ever, or is it just a matter of who can resolve the differences?
Yeah, the size of the assets really don't usually have a big bearing on whether a case can be resolved through mediation or arbitration. In fact, sometimes it's easier. I had a case once where I was mediating, and it's one of the few, I gotta say, one of the few that I wasn't successful at resolving through mediation, but I was the mediator. And it was a very large estate divorce. And I went back and forth between the parties. And the biggest asset in the marriage was a family-owned business. And I said to the family member, I'll say, that owned the asset and whose family it was that had owned the asset, don't think about this as dividing up an asset in the divorce, but think about it as a business transaction. And you have been in the process of buying out other family members before, so think about how you would approach it from that perspective. And that really got the person thinking in terms of business and not divorce, and how he could come up with a number that was fair for a business transaction. And then the other side, I went back and I said the same thing. And we did actually get to the same number. What we could never resolve, and what the lawyers on each side couldn't agree to, was the form of how it would get paid out, because one side wanted it paid in a lump sum. There wasn't enough money to do that, and the other side wanted to pay it out over time. And so that's why it never resolved. But big asset could have been resolved through mediation and probably should have been.
Certainly, though, in the example that you're giving, you've made a considerable amount of headway. What happens then if it does have to go to litigation? Is all of your work then upended, dissolved, and starting over from scratch? Or do the parties involved take the resolution as far as you could take it, and then just in court resolve how it's going to be, the last pieces fixed? How does that work?
That's up to the parties and the lawyers. They could do that if they want. They could say, Judge, we have a stipulation on all of these issues. This is the one issue we can't decide on. Or anything that is done in mediation is confidential and cannot be raised in court. So if they don't want to use any of the results or headway that we made in that case, either side can say nope, and no one can raise anything that was discussed or agreed to even in mediation because it's confidential. So in that type of situation, there's no reference to it, and it can't be used unless the parties agree. I also, as the court annexed arbitrator, had a very interesting case where there was a claim for unjust enrichment. Somebody had done some work on a building. The building then got sold to somebody else. The payments were never made, and there was a claim that the value of the building had been increased by the work that was done that was never paid for. So I actually went out to the building with the attorneys and the parties and took extensive notes on what had been done, what increased the value in my opinion, what didn't, how much it increased it by. And I gave a decision on the law and the value of the improvements. And it was rejected by one side. They went to trial, and at trial, the judge bifurcated it into the legal issue and the factual basis for that legal issue as to whether there was unjust enrichment, and then the damages. And so after the trial on the initial part, where the judge found that I was correct, even though he didn't know what I found, that there was some unjust enrichment, the parties then said to the judge, well, we can then stipulate to all the work that was done in my decision on the damages. So they adopted the damages in that case. Again, that arbitration would have been confidential and not subject to disclosure to the judge or jury if there had been a jury in that case. But the parties chose to use the damages that were assessed in that case as the basis for the award.
I get it. So one other piece that I guess I'd want to follow up on. If you have been a mediator and it's not completely resolved and it ultimately is going to go to a court, are you then allowed to represent either one of them, or are you just removed from that entirely because you already served as mediator?
So the answer to that question is, if there is a contest over an issue, then the mediator shouldn't get involved in the middle of that because there is a potential conflict of interest. The interesting question would be in a divorce mediation, for example, where it's all resolved, and then the parties ask the mediator if he or she could put the divorce through for them and they've got an agreement. The rules of ethics, as I interpret them, say that the mediator could actually do that because if there is a conflict of interest or a potential conflict of interest, the parties have the right to waive that conflict of interest. So as long as it's disclosed and it's in writing and the parties sign off on it, that can be done. We have determined that it's probably not a good practice, so we do not do that. But I don't think that a mediator is precluded from, for example, putting through an uncontested divorce, as long as they follow the rules of ethics, which say that if an attorney has a conflict or even a potential conflict of interest, that it's disclosed and all the parties sign off waiving that interest, that conflict.
That's good information for people to know. So while we read that there is increasing popularity and more people are embracing the idea of mediation, the other side of it is apparently the Harvard researchers have found that there are enough stigmas that it isn't being adopted as widely as you would expect. And they talk about it in the business realm. Does it make sense, or would you agree, David, that one of the reasons that businesses wouldn't get involved in mediation is that they are just not willing at the outset to think that they would be able to handle it through mediation? What is there? Is that a narcissistic personal issue rather than someone just wanting to do what could save everybody a lot of money and grief?
Yeah.
Speculation here, David.
Yeah, it's all speculation because you would have to know what the particular facts and issues and what's in dispute and why they hold that belief that mediation couldn't possibly be successful. Now, I will say that, for example, class action lawsuits, can those be subject to mediation? Well, yes, because there's a representative plaintiff and an attorney who represents that class of people, and that could go to mediation for settlement. So I can't really think of offhand a type of case where a dispute between either businesses or business and consumers or something of that nature couldn't potentially be resolved through mediation. Because again, mediation is just asking two parties to be reasonable, set aside some differences, listen to each other, and come to a conclusion that they both accept.
And you'd think that that could get them to that theoretical win-win where in a court you don't always know whether it's jury or judge.
Right.
But apparently there still are some obstacles, so people have to work on their communication, I guess.
Although we do say that a successful mediation is one where neither party feels like they won, but are both satisfied with the result or can live with the result.
It's acceptable.
It's acceptable.
Well, thank you. We want to thank David for his help serving as both lawyer and as weighing in as mediator. Do you have a preference, by the way, which one you do?
I enjoy doing both.
Okay, fair enough. We wanted to thank you for tuning in. We say that the law matters, and please do tune in because the law matters to you.